Hello, my name is Tara Schick. Today I'm presenting a state case out of the state of Texas. The case is PETCO Animal Supplies Incorporated, Appellant versus Carol Schuster, Appellee. This is not a trial, but an appeal to allow PETCO the opportunity to argue the original judgments and allow Schuster to defend the original trial court's judgments. I am presenting this case for my Legal and Ethical Issues in Veterinary Technology course. PETCO Animal Supplies Incorporated Appellant versus Carol Schuster Appellee is out of the Court of Appeals of Texas in Austin. The case was decided on April 29, 2004. The case number is listed below. Carol Schuster owned a 14-month-old miniature schnauzer named Licorice that got loose while being walked by a PETCO groomer on January 16, 2003. In Austin, Texas. Licorice was found deceased 4 days later from being hit by a car. Schuster is suing PETCO for breach of contract, gross negligence, and conversion. On the slide, it shows what Schuster sued for versus what she was awarded in the original judgment on April 29, 2003. As you can see, the amount awarded for mental anguish, loss of companionship, and exemplary damages was significantly reduced in the original judgment. PETCO is appealing 4 counts of the original judgment based on lack of evidence and support of Texas law. PETCO appeals 4 counts of the original judgment in regards to Texas law does not support any award for mental anguish and related counseling, loss of companionship, or lost wages for the loss of a dog, as dogs are considered property. No evidence of conduct by PETCO to support imposition of exemplary damages. PETCO finds the attorney's fee award to be excessive. The district court awarded both breach of contract and tort damages for the same injury. Helgeman was a case that involved the poisoning of several dogs resulting in the death of the dogs. This case has been a guide for how cases are handled involving the loss of a dog in the state of Texas. In the state of Texas, dogs are considered personal property. Helgeman states that the damages for the loss of a dog can be identified as market value if the dog has any or some special or pecuniary value to the owner that may be ascertained by reference to the usefulness and service of the dog. Helgeman remains the guiding case for lawsuits in Texas involving the loss of a dog. As we continue, we will see how Helgeman plays a role in this appeal. Schuster's claim for mental anguish involves being terror-ridden while searching for Licorice and the fear she suffered each day not knowing what happened to him. Schuster does not attempt to defend why and how this dog grooming incident falls within the narrow class of intensely emotional and non-commercial subjects that could lead to mental anguish damages from a breach of contract case. Another Texas court to have subsequently addressed this question established that grossly negligent property damage can support a claim for mental anguish if there is evidence of some ill will, animus, or desire to harm the plaintiff personally. There is no evidence of this in the case against PETCO. The courts reversed the trial court's award of mental anguish damages in this case. Since Schuster cannot claim mental anguish for this case, the court has reversed the award for counseling expenses. There is no evidence to support the necessity of this medical expense. In the case Jackson v. Gutierrez, it demonstrates that in an appeal, failure of default judgment plaintiff to present proper evidence of reasonableness and necessity of medical expenses, then the medical expenses award would be reversed. Intrinsic value is a personal or sentimental value placed on something. Schuster requested $280,000 in the loss of companionship damages based on the average life expectancy of a miniature schnauzer being 14 years of age. She multiplied the age by $20,000, which is what she would consider Licorice worth based on what she would require to make as a salary to leave Licorice at home for a job. Intrinsic value damages are only recoverable when the property is shown to have no market value or replacement value. In this case, Schuster testified Licorice's replacement value was $500. The Court of Appeals uses the precedent set by Hilgman to reject Schuster's damages to include intrinsic value of loss of companionship. The court reversed the trial court's damage award for intrinsic value. Lost wages are not applicable in Schuster's tort case, as Likes informs us, while few persons suffering serious bodily injury would feel made whole by the mere recovery of medical expenses and lost wages, many whose property has been damaged or destroyed will be entirely satisfied by recovery of its value. Under the breach of contract theory, Schuster's lost wages claim is not supported by the Supreme Court, as it has been stated. Consequential damages are those damages that result naturally, but not necessarily, from the defendant's wrongful acts. Thus, to be recoverable, consequential damages must be foreseeable and directly traceable to the wrongful act and result from it. The court reversed the trial court's damages award for lost wages. Exemplary damages. PETCO argues there is no evidence of gross negligence conducted by individual employees that can be attributed to PETCO, and exemplary damages are not recoverable for a breach of contract. Exemplary damages may be recovered against a corporation if the negligent act is the act of the corporation itself, not based on the actions of an employee. Schuster claims that PETCO approved the actions of the negligent employee by allowing them to search for licorice. However, this cannot be proven in the record. The court reversed the trial court's damage award for exemplary damage. PETCO argued that the attorney fees were excessive for a default judgment case. Schuster's attorney charges $150 per hour and spent 45 hours on this case. The court upholds this judgment based on the 8 standards set by the Supreme Court for assessing reasonable fees. The court overrules PETCO's appeal on attorney fees. PETCO argued that the district court was in error by allowing Schuster to claim damages for both breach of contract and tort claims. After this proceeding, this is a non-issue due to the reversal of some of the original judgments. In conclusion, 3 of the 4 counts PETCO challenged were reversed. The court reversed the original judgments of mental anguish damages, counseling cost, intrinsic value for the loss of companionship, lost wages, and exemplary damages. All other judgments are otherwise affirmed. This is a list of references from both the presentation as well as the pictures. Thank you for watching.